Let's start off talking about license requirements, maintenance, and education. And the first thing I want to hit is that the mission of the Real Estate Commission is to protect the public. None of the laws that we review that I've condensed for you in your handout or in this review video, we're not going to cover everything. We're hitting the highlights. But I do think it's worth it for you to know that the mission of the Real Estate Commission is to protect the public, not us. Any squabbles that we have between each other of, you stole my buyer, you owe me a commission split, anything that we might have as a controversy between agents or between brokerages, you've got to settle that through attorneys, strongly worded letters, mediation, or maybe even court. Okay? This is all about protecting the public. And another way that they might ask this is a way they protect the public is by establishing license requirements, how to get a license maintenance, how to keep your license, and what education you must do to maintain your license. That's how they protect the public, is basically by having standards. Okay, so that's a great test question, in my opinion. Now, we need to know the red light, green light of when you need to have a real estate license and when you don't. And as a reminder, we are talking about brokers initially to get licenses, because you cannot work independent as a salesperson. You must work under the managing care of a broker, correct? Correct. So I think it's pretty clear that to represent someone, buyer, seller, tenant, or landlord, you've got to have a real estate license in order to prepare leases or real estate contracts, advise them on the value of their property, negotiate, advertise a property for rent or sale. I think you're very familiar with what we need to have a real estate license to do. But there are 3 exemptions or exceptions to that rule. Number 1 is you do not need a real estate license to sell your house for sale by owner. My neighbor across the street has got a lot of vendors in and out of their driveway today. They must be remodeling their kitchen. They want to sell that. They can do that as a for sale by owner unlicensed. Another really good example that you could have on the national or the state of someone that can act on someone else's behalf and not be licensed is a power of attorney. It's that legal written authorization to act on someone's behalf. And of course, specifically, we're talking here about real estate. So if I said Mary is selling McKenna's house, what is Mary and McKenna's relationship? That means Mary is McKenna's power of attorney, POA. The other big exemption I want to note here is a resident property manager is exempt. So if the property manager lives on the premises where they're also working on leases, that's in conjunction with where they live, they are exempt from having a real estate license. Now, where I think we've got some beef is the requirements to get a salesperson's license. Now, I know you're familiar with background checks, the 4 courses that are required. Another big rock might be getting errors and omissions insurance. But here are some details I do want to add and clarify. Number 1, you've got to have your broker selected at the time of application. You cannot apply for your license and then think, I'm going to interview and decide who I want to work with. No, that person has to be selected when you apply for your license. You cannot apply as inactive status, is what that also means. You've got to be 18 years of age or older. Do not let the exam mess with your head and convince you it's 21, like to buy beer. It's 18. And there's no requirement of a high school diploma or GED equivalent. In fact, I had a broker tell me one time that she had an agent that did his real estate classes over Christmas break. And then when he turned 18 that spring, got his license. And on the day he graduated from high school, he had a closing. Okay. So cashing checks and snapping necks, right? So GED or high school diploma or equivalent is not on this list. Let me point out those two of what's not on there. The other thing I want to note is obviously we have discriminatory practices, but one thing that it talks about specifically, besides protecting those standard protected classes of race, sex, religion, marital status, national origin, let's talk specifically about citizenship. Iowa code says that your citizenship information may be required on the application, but it's not a reason to deny your license. And I've seen almost that exact verbiage, how it's written in the Iowa code on the exam. The other thing that's big about education is that a real estate license is good for 3 years. Your first year counts as a full year, and all licenses expire on December 31st. Giving you a lot of nuggets there, right? Licenses last for 3 years. The first year counts as a full year, and all licenses expire December 31st. So if I got my license today, October 15th, 2025, I would have the rest of this remaining year, 2026 and 2027. My license would expire December 31st, 2027. Now, brokers have a lot of commonality. The same thing applies as 18 years of age or older. It is what it is. That comment about citizenship being on the application, but not a reason to deny you. It's the same. A broker's license also has a 3-year renewal period, the first year counting as a full year, and their licenses also expire December 31st. What you do need to know about them is they're required to take 60 hours of pre-broker education, and they must be actively licensed for 24 months. 24 months equals 2 years. Just in case your brain has a little moment at the test center. 24 months equals 2 years. There is no requirement for number of transactions, number of years in leadership, not a minimum amount of volume sold. None of those are requirements. It's 60 hours of pre-broker courses. Of course, you've got to take an exam, and you've got to be licensed for 24 months preceding. Then I'm going to add something here for you that we've already discussed. But the question is, when must you apply for your license after you pass the real estate exam? When must you apply for a license after you pass the real estate exam? And the answer is it's got to be done by the last day of the 6th calendar month. The last day of the 6th calendar month. Now, when I passed my broker's exam, I applied yet that day. I came home with my passing certificates and I applied that day. I did not mess around. But the real answer is if we got our license or we passed the exam today, October 15th, 2025, we would have until November, December, January, February, March, April, the last calendar day of April, which would be the 30th. That would be the deadline. Now, for license maintenance and approval or renewal, license maintenance and renewal, to renew your license, you've got to have 36 hours of continuing education. The other thing I'm going to add here, even though I don't necessarily promote it, it is an option that with permission from the Real Estate Commission, you can take the real estate exam in lieu of continuing education. So 36 hours or take the exam in lieu of CEs. I call those continuing education, CE. Now let's talk about those 36 hours of CEs. 24 of it is going to be approved electives of your choice. And then 8 of it must be mandatory law update. And 4 of it must be mandatory ethics. If you don't do your continuing education, you still need to renew your license, or they recommend that you do, but you will renew as inactive status. And anytime our license is inactive, what are we not doing? We are not selling real estate. We're not selling real estate. Now, let's say you forget to renew your license. I've had this happen. I had an agent, I called and I said, hey, your license is expired. Did you not renew it? He's like, yeah, I did my continuing education. Good. But you forgot the second part where you go in and renew your license with the Real Estate Commission. Glad he had his CEs done, but he forgot to renew the actual license, which means it had expired. And again, that means he should not have been selling real estate. Here's what happens if you fail to renew your license. The Real Estate Commission is going to give you a 30-day grace period to January 30th. I did it again. They're going to give you a 30-day grace period to January 30th. And with that 30-day grace period, you're going to need to pay a $25 penalty. Now, what is grace period? What does that grace period mean? Does that mean you can still be selling real estate? No, ma'am. No, sir. Your license is inactive. It's expired. So what does it mean by grace period? Well, the grace is that you don't have to start from scratch with a brand new application and do a background check and take these courses and start from scratch. In fact, the law says that you can pay this $25 a month penalty for up to 3 years. And then if you don't reinstate, you've got to start all over, which includes this class of 60-hour pre-license. And then I'm going to reemphasize anytime your license is active, you need to have errors and omissions insurance. You need to have errors and omissions insurance. Now, let's talk about termination or transfer of a license. Let's say your broker says, Amy, you don't work here anymore. Or let's say I go into my broker and I say, I quit. I quit. Your license gets returned to the real estate commission. You're now inactive, which means you're no longer selling real estate. And until you find another broker that's going to host your license, you're not selling real estate. You're not advertising yourself. You're not promoting property. If you want to make a change between brokerages and have it be seamless so that you don't have that downtime of being inactive, here's what you need to do. And this language desperately needs updated, but I want you to think of this as a physical piece of paper. If you're going to make an uninterrupted transfer from one brokerage to another, the first step is you have a brokerage sign saying, yes, we want Amy. We'll take her. The second step is you have your current brokerage release you, and they've got 72 hours to release that license. And then the third step is you need to confirm that you want that transfer. And that's probably a good law so that I don't try to trade real estate agents at my brokerage like they trade baseball players. That way I don't have an agent come to me and say, Amy, I want to move brokerages. And I say, well, if you want to move, tell them I've got to have Carmine and Jared in exchange, right? No trading. Let's talk disciplinary actions. And you've got 4 test questions here. Number 1, I do think you need to know some actions that would create disciplinary action against you. My 2 big ones are undisclosed dual agency. You can represent a buyer and a seller in the same transaction, but it's got to be disclosed. They've got to agree to it. The other big one I think we need to note is, can you accept a real estate commission, a bonus outside of closing? No, no. That's got to be documented. Go to your brokerage, and then your broker will pay you according to your independent contract or agreement. Then I would know my way around a little bit how the complaint process works. But if you do have someone file a complaint against you, the commission will do an investigation. And they can use lots of findings like newspaper clippings, court records to help support their evidence. And basically, they're going to make one of 2 decisions. Amy did not violate any laws. We cannot find any evidence. This is not substantiated. They're going to dismiss it. The second option is Amy didn't quite follow the law here. We think she's guilty. And what they're going to do is they're going to have a hearing. And I'm going to get to show up and defend myself. And if I choose, I can even have representation with me, such as an attorney. I can bring witnesses. I get to prove my point. Now, before the real estate commission can have this hearing on charges, they've got to give you a 20-day notice. I know that's a weird number. You want to just think it should be 30? No. 20-day written notice before they can have that hearing. And then you've got 10 days to respond to that. So if you don't respond to it, they're going to have that hearing without you. And then let me add something here for your career that's also a state law. Is the real estate commission requires you to update your home address with them on file within 5 days of moving. Real estate commission has a rule that says if you move, you got to update your residential address with them within 5 days. Guess why they do that? Is so that you can never have an excuse that you didn't receive their notice. Because I had an agent one time, had a hearing. Well, I didn't know about it. I didn't get notice. And the real estate commission said, well, we sent it to this address. Oh, yeah, I haven't lived there for a couple of years. And then that was the second violation. I would know some of the disciplinary actions that they can revoke or suspend a license, that they can require additional continuing education. And then the unique one is they can order a physical or a mental examination. And they can request periodic reports. Then the other one that's normally kind of separate-ish from these penalties, but it is a penalty, is what is the maximum civil penalty that the real estate commission can charge? And the maximum penalty is $2,500. Not $5,000, it's $2,500. And you're allowed 3 violations in 3 years. Then I would also review things they might consider when they're determining your disciplinary action. Have you done this before? When was the last time you had a complaint filed against you? What was your intent? What was your financial gain? Now, we know that a prohibited practice is accepting a check outside of closing. We know that a prohibited practice is undisclosed dual agency. I also want to add here that another prohibited practice is these tying agreements. We learned about them. We've also called them tie-in agreements when we were reviewing practice of real estate and those antitrust laws. This is also a part of Iowa code that says if a builder wants to buy one of your listings, you cannot refuse that sale in an effort to secure the listing with them when they build the new house. You cannot tie the sale of that lot to the listing of that new construction home. You can get hired to do both of those things, but they've got to be 2 separate transactions, not linked or tied together. Now, for trust accounts, you've got 3 test questions, but you've got a lot of options they could ask you. Now, we know a trust account is a type of escrow account that we use in real estate to store other people's money. Security deposits, earnest money checks. And here's how it works. your broker is the one that can have a trust account, not you as a salesperson. The account has to be in a federally insured bank or lending institution. And it's got to have the word trust in it. It's got to have the word trust in the title. And then the other major one, this might be the major of these three things, is the account must be interest bearing. And the interest gets transferred to the state of Iowa on a quarterly basis. Earnest money checks and deposits must be deposited within 5 banking or business days. And if that one's not on the exam, I'm going to be disappointed. That's to me, that's one of those questions that should be a rite of passage to get real estate license on the exam. Now, we again know that when it comes to a trust or escrow account, we cannot commingle money between the trust and the general business account of the brokerage. But the law does state that the broker can carry up to $1,000 of their own personal money in that trust account. And again, that's going to keep it from going to a zero balance. It's going to cover any bank fees, and it's going to cover any check fees. That's why they're allowed to have it. When it comes to releasing earnest money, in order to release it, we need signatures from buyer, seller, tenant, or landlord. You as the agent don't get to make the decision. We've got to get it in writing on who and how that money is going to be released from a trust account. And that's got to be signatures from your buyer, seller, clients. The only time a broker can release it without signatures is because the offer was never accepted by the seller to begin with. Then the broker can refund it, no questions asked. Now, a broker does have some other layers to this and some other protection to keep their trust account clean and tidy. But this is what you need to know as someone who is going to be employed by a broker. We don't just decide in the moment who gets the money. Even if it says in the contract that the buyer gets it if they lose their job, we still need buyer seller signature to distribute it. Now let's talk closings. Your broker is required to keep a copy of any trust information and any transaction files for 5 years. This is here, and it's also under broker responsibilities. So this is another one that is very probable to me that you need to know all documents need to be kept for 5 years. And before a transaction closes, the broker is required to give the buyer and seller a list of all of the fees related to that closing. The next question that comes up is, could I use my puppy Hazel? That's a sweet thing. Could I use my puppy Hazel as earnest money? And the answer is yes, as long as that was disclosed with the original offer and the seller accepting it. Now, if I ever did that, you'd want to call the hospital or authorities. I would need mental attention. But the real answer is yes, you can use a personal item as earnest money, car, boat, diamond ring, but it's got to be disclosed with the original offer. Otherwise, if you write $1,000 as earnest money, just as an example, it's got to be cash or an immediately cashable check, or most of us are now doing electronic transfers, but it's got to be immediate. Otherwise, if it's any deviation of that, it's got to be a part of the original offer accepted by the seller.